Successfully completed. Good morning, sir. Very warm welcome, sir. Dr. G.R. Raghavender.
Now,
Good morning, sir.
Good morning, sir.
Very warm welcome, Dr. G.R. Raghavender, sir.
Yeah, thank you. Thank you very much, sir.
I, Dr. Dinesh Patil, request Dr. introduce today's eminent speaker, Dr. G.R. Raghavender, in 5-day FDP program.
Good morning, sir. Good morning to one and all present here on behalf of SPC Mumbai and Hindi Seva Mandal, Shri Sant Gadge College of Engineering and Technology, Bhusawal. I, Dr. Shrikant Chaudhary, co-coordinator of 5 days national level FDP on innovation, research and IPR journey towards excellence, welcomes guest speaker faculties and participants. Now let's start our FDP's fifth session by introducing our speaker. I heartily welcome today's eminent speaker. Sir, it's a great pleasure for me to introduce you for this session. Dr. G.R. Raghavender sir is our first speaker for today's session. Dr. G.R. Raghavender sir is a retired civil servant from Central Secretariat Services CSS 1988. He worked as Joint Secretary, Department of Justice, Ministry of Law and Justice since January 2017. He was also Mission Director for the National Mission for Justice, Delivery and Legal Reforms. His driving policy reforms for improving enforcing contracts parameters under the Easy of Doing Business and e-courts project. Earlier, he was Joint Secretary in Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India, New Delhi. There, he also held additional charge of Director General, National Productivity Council, NPC, from December 2015 to May 2016. He is former Register of Copyrights of the Indian Copyright Office. He played a key role in introduction of the recent amendments to the Copyright Act in 2012 and the Copyright Rules 2013. He attended many WIPO SCCR meetings and FTA negotiations as a member of Indian delegation. He made significant contributions to recently concluded two WIPO treaties, namely Beijing Treaty on Audiovisual Performance 2012 and the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled 2013. He has contributed in revision of the copyright legislation of Bhutan, Kampuchea, Myanmar, and Nepal as a copyright expert. As a resource person, he gives lectures, talks on copyrights and related rights in various international and national seminars, workshops organized by WIPO and by several law schools, universities, and institutions all over India. He has recently been awarded PhD IPRs from GG SIP University, New Delhi. He holds several degrees and postgraduate degree, namely MA Development Studies in Public Policy and Management from Institute of Social Studies ISS, the Hague, the Netherlands, MA Gold Medalist and MPhil Ancient History and Archaeology from Osmania University, Hyderabad. He was a junior research fellow scholar of UGC as well as holds a LLB degree from Delhi University and LLM IPRs from GGSIP University, New Delhi. He also holds bachelor degree in library and information science and BSc degree from Osmania University, Hyderabad. We are incredibly fortunate to have such a wonderful and dynamic personality with us for this session. We are overjoyed, sir, to hear you as a resource person for this 5 days National Faculty Development Program. Now, sir is going to brighten us with the topic copyright insights and related strategic issues. Now, I would like to invite Dr. G.R. Raghavender, sir, to start the session and address our participants. Over to you, sir.
Thank you.
Sir.
So, Vande Mataram. Good morning to all of you. Namaste. And thanks for the generous introduction given by Dr. Srikant Chaudhary ji, and also inviting me to be a guest speaker for this faculty development program. The Sant Gaje Baba College of Engineering and Technology, Bhusawal, Maharashtra. And this is a great occasion to interact with all of you, various faculty members of your university. And just a minute, some technical issue. You all can hear me?
Yes, sir. You are audible, sir. Please continue.
Yeah.
Please share your slides, sir.
Actually, I'll be speaking often without the help of any PowerPoint presentation. Hello, is it okay?
Yes, sir. Okay, sir.
Yeah. Intellectual property law is associated with our lives every day. You may be creating or innovating any technology or innovation and creation leading to a creativity. And most of you, the faculty member of engineering college, you may be deeply involved in research and development of particular project in a particular area of engineering. You may be computer science, data science experts, or the most disruptive technology like artificial intelligence and 3D printing, or maybe data analytics, and all these most emerging areas. Or simply you might be writing various books on various topics, or writing chapters, or contributing to a famous journal, writing articles. It may not be strictly restricted to the science subjects or engineering subjects. The faculty members from the law, other social sciences, art subject are also involved in creating content in their respective areas, doing very intelligent and innovative, creative research. So how this copyright law is associated with the work you are doing, and doing, and the past you are done, and future also you'll be doing. Gurukul. You know that earlier days students used to join Gurukul, and at the end of their course only, they used to give Guru Dakshina. And most of the time, they used to learn by heart from oral traditions were there. And this went on till they started writing on the various leaf-based book systems started inscribing on that and all that. But the similar thing was there in the Western countries also. And the calligraphists were engaged writing the books. But even though after discovery of an introduction of paper, they called it papyrus, from there the paper came. But there was no problem of copyright at that time. But when Gutenberg introduced disruption by inventing a printing press, then question came, when author who has a copyright and he has given to that exclusive right to publish, print and circulate to the public, getting the exclusive license, how come without license and doing piracy and printing it? To protect the author interest, mostly the printer's interest, in 1609, a first Copyright Act was developed and introduced by the British Royals in the Privy Council, that is Statute of Anne, and that came into effect in 1610. Basically, they introduced 14 years exclusive right initially, because they said that the owner of the right should have the exclusivity to exploit that. During that given period, the economic rights have to be exploited. Then technology started growing, and even though globalization started recently, at the time, in a minuscule globalization was there. English books, the literature books started traveling to French, German, other countries, and other country literature also used to come to England. They used to translate. Then question of translation right came in the copyright. So new economic rights started getting inserted into the copyright law. Then there were two systems were there. One is the common law system, which were from the Commonwealth countries mostly followed the UK system of copyright law. Whereas the civil law countries, the continental countries, which normally call the France, Germany, Italy, Spain, other countries, they had a civil law-based system, unlike the common law of the UK and other Commonwealth countries. They're dealing with the copyright different, because in the common law countries led by UK, economics, business played key role in formulating these copyright law. Their focus is owner, right owner. Who is the right? If it's publishing, okay. But mostly authors, they pass it on to the printers and publishers. It started a practice during early 17th century, and that continues till now. And then where in the civil law countries, they said author's right is important. The author can give a license to publish, but he can't transfer the rights. And publisher can't become a right owner. That is the difference there, the main difference. And for them, the protection of author's rights became very important. Then question came the various differences, the length of the copyright and the way deal with the other economic rights. So a lot of differences were there. Then also came issue of piracy. Two examples I give you the piracy during that time. The many English and French literature, which became very popular in 16th and 17th centuries, they were translated and printed, published and circulated in the Dutch language in the Netherlands without taking any license or permission from these English and French writers. That became a big issue. when this was brought before the Dutch king, and they simply neglected, it is being published in the Dutch language, go to hell. And then say Dickens, the famous English author, became a multi-billionaire writing so many popular books. And when he traveled to Washington and New York, when he found that, especially in the New York, the business city, the commercial city of America, that books are being printed and sold, his own books, without his permission. When he brought this to the notice of the authorities, and the information leaked to the newspapers, and Washington Post wrote an op-ed ridiculing Charles Dickens, that the billionaire author is begging for royalties in the streets of New York. But they didn't realize that there is a copyright law, and copyright is being infringed. What they are selling is pirated versions without taking permission, and causing a lot of economic harm to the other authors or right owners. Then, with the efforts of famous French authors like Victor Hugo, Alexander Dumas, they collected various authors. They formed the authors conference in the Bern, and that led to that they decided, similar to the the industrial property rights convention. They should have just like a Paris Convention for the industrial property rights of 1883, they wanted a international convention protection of authors' rights. And in 86, they finalized Berne Convention, the first convention to protect the authors' literary and artistic works, called Berne Convention, came into existence, and it was amended 7 times. And then when technology grew, then there was a need for protection of performers, broadcasting organization, and sound recording companies called phonograms, which Berne Convention could not address, because basically convention protecting the author's rights, not the protection of related rights. Why these are all related rights? Because a performer, he sings a song based on the already existing literary work produced by the author. And when a music company or a phonogram company does a recording, they get a sound recording right, but that is based on the music created by the music composer who has music right, and the author who has a literary work right, and the performer who has a performer right. So again, it is a related right the phonogram company or sound recording company is creating. Then third comes the broadcasting organization. At the time, the radio stations were mushrooming, and little by little, the television broadcasting also started popping up. That gave a big platform for music companies and also the singers to exploit their works. Then they needed protection of broadcasting organization, their right of protecting their broadcasting right. Then Rome Convention came in the 1960s. But started exploiting it, new technologies disruptions came. And this tape recorder created a lot of problems. Those who remember the cassette, 60-minute cassette and 90-minute cassette. And these things songs could be recorded and sold in the market. That's how the history said the T series cassette industry grew to a big, huge music company nowadays. And they came down, especially India was also interested to stem the piracy, music piracy at the time, because India was one of the leading phonogram and sound recording companies because of the not only the popular Bollywood music, because entire music industry from Telugu, Tamil, Malayalam, Kannada, Bengali, and Bhojpuri and all that, they wanted protection, these music companies. Then Geneva Phonogram Convention came in 1971. And India is one of the first countries to not only negotiate, sign, and ratify that treaty. Then again, technology started giving problem for these broadcasting organizations. At the time, the satellite broadcasting became practice. Those who remember the Doordarshan, we used to have, as a kid, I remember we used to simply manipulate the antenna to the direction of the high power transmitter or low power transmitter set up in our town so that we get a clear signal. That signal broadcasting started initially with terrestrial broadcasting from the main station, earth station to these transmitter. After technology came, satellite broadcasting started. When satellite broadcasting started, there is a theft of this satellite signal before it reaches your television monitor. So the cable operators started, this kind of theft and putting their own advertisement. They needed this. Though finally, they wanted a treaty that came finalized as a Brussels satellite broadcasting convention. But unfortunately, the new technology was already there. That is the DTH technology, which we have nowadays, which started in early 70s. So there was a need to protect DTH broadcasting, but the negotiators made a big mistake, not including in their language this new sprouting and emerging technology. Then that is the reason why only 32 countries have signed and ratified. And for this treaty to become effective, at least 60 countries needed. Then came the TRIPS convention because, the globalization, the protection of intellectual properties, both industrial properties and copyright related rights, became important. So and that was became a part of this WTO, the World Trade Organization, and a special agreement in the bouquet of agreement was drafted and included and signed and ratified by all the countries. That's called trade-related aspects of intellectual property rights TRIPS agreement, which came into effect from 1st January 1995. Then, during the negotiation of TRIPS, few developed countries raised the issue of covering the.
ड्राइनेस अंता दी फेस ते नजर आ रही है.
Please, others, please mute your mics, please. And many countries like Japan, US, and EU countries said the growth of internet and availability of content over internet is being unauthorizedly pirated. And to stop, even though internet gave advantage to the copyright owners and authors to sell their content, not only in the cities, in the countries, with this internet, which where borderless globalization it started, they can sitting in the homes, they can sell the content. Even though their royalties increase, but online piracy stem their economic progress. And then new technology came, encryption devices. These encryption devices were started used by all authors and right owners over internet, locking their content, just like you have used the Netflix, Amazon Prime during the pandemic. When lockdown was there, you were restricted to your respective homes. How did you get access to these streaming platforms? You first pay a certain amount, let's say that 500 rupees per month for a television channel to stream this Netflix, and you have a login ID and password. Similar system was introduced at the time. But there are hackers who started hacking and de-encrypting these devices. There were two kinds of devices used by the copyright content manager to manage their digital rights management. One is the access control, where you get a login and password after paying certain payment online. So you are allowed to access the content, similar to Netflix, where you access the program and watch it. Then copy control. So those who want to download, so another amount has to be paid. Then they will be allowed to download that. That too, again, another thing is there, you can't copy it. Copying is allowed only for downloading that particular device, but not peer-to-peer sharing and creating a headache with the piracy. So this could not be addressed in the TRIPS because already the Uruguayan round, which finalized the TRIPS agreement, which finalized the WTO agreement, took more than 30 years. So introducing new elements they didn't want to delay. So they gave this mandate to finalize internet treaties to another United Nations body called World Intellectual Property Organization, WIPO, based on Geneva. In 1996, WIPO came out with two important treaties. One is to extend the Berne Convention for protection of literary and artistic works of authors to the digital environment. The treaty is called WIPO Copyright Treaty 1996. And second treaty was needed, extending the Rome Convention to digital environment. Then a tussle started between protection of oral recording of these phonograms and audiovisual recordings. And oral recording, the way it is, protection is given, the rights are managed similar. But coming to audiovisual, a lot of differences between the work for hire concept of the United States and other contractual system existed in the EU countries, Japan, and India, and all that. They finally decided that to remove the protection of audiovisual performances from the phonograms treaty. They had only oral recording protection in the WIPO phonograms, performers and phonogram treaty, which was finalized as one of the WIPO internet treaties in 1990s. So in this way, as and when technology grew, the international conventions and law changed their shape to protection of authors and right owners of this content, innovative content they create, and various industries benefited, whether it is publishing industries based on authors, or phonogram industry based on singers and the music composers, again, authors of those songs, and film industry, which contains not only the producer is the author of the films, because he's the one who takes the initiative and risk of completing the film and releasing in the theaters. He's the author, but where various works are synchronized in that. The synchronization of literary works, artistic works, performer, everything takes place there. And then only one cake is prepared, that is called film, which has so many pieces. Various rights come together to create one right, or the cinematograph film right, which is owned by film producer, the film production company. Then author. Let us see who is the author. Author is the person whose original expression gives rise to various works. Take, for example, literary works. You have books, articles, journals, and including computer software is a literary work. And why you say that computer software is a literary work?
Excuse me, sir.
Because when technology was introduced, ICT technology, question came before all intellectual property rights expert, even while negotiating and finalizing TRIPS convention. If you see the Article 27 of the TRIPS, which protects the patentable subject matter, what does it say? Article 27, it says, patent shall be granted in any field of technology, either product or a process, provided this has novelty, inventive step, and commercial application. So, any field of technology means ICT is a technology that deserves patent protection. But countries like India, which had comparative advantage already by 95, 80s, what happened in the Bangalore, followed by the concept of Silicon Valley in United States. In early 80s, another Silicon Valley started in Bangalore with by the brilliant uh, entrepreneurs and management experts and software experts. That's why we have in Infosys, Wipro, and various other software firms and IT firms came up there. Then what is the advantage if you give a patent protection and the any licensing of this software become very expensive? But India wanted only copyright protection for that. There are some advantages of extending copyright protection to software, not to giving patent protection. What are the advantages? Forget about the lengthy exclusive right of duration of protection you're getting. That life of author are 60 years. You don't need such a long protection on software because it is the most disruptive, innovative field. Within a 6 months, you get a new software. You all have mobile phones, either iOS software based or Android. You keep updating your versions, software versions. You don't need then the old version become obsolete. You don't need a life of the author. During the life of the author itself, he must be creating a number of versions of a particular software. So what is the advantage there? That more innovation is there in the copyright. It allows, whereas patent blocks it for 20 years, and there are exceptions provided to the exclusive right given. Sorry, it went off for some technical reasons. Now I continue. And there is a concept of copyright exception for re-engineering. So re-engineering is not a kind of piracy, but one expert, skillful software person can take any software and break it open legally and develop uh, uh, a particular after reading the source code and object code, and you can innovate a better product which has originality in that creation. That's what flexibility in the TRIPS agreement was introduced. If you see the Article 10 of the TRIPS agreement, para 1 of the Article 10 of the TRIPS agreement says that computer program, along with source code and object code, is a literary work as defined in the Article 2 of the Berne Convention. What is this? When Article 27 says ICT, software is a ICT and it's a patentable, it is implicit there. Then why do you need? Because it's a flexibility for countries like India who wanted to extend software protection for the copyright, not the patent. It's because the Article 2 of the Berne Convention, which defines literary work, says that original expression written in any form. So computer program code, whether source code or object code written, original source code, object code written in that form, that is why it is called literary work, and including the computer database. So I'm just opening up the protection of copyright, the nitty-gritties of this now. Computer program also, not only the computer program, computer database also a literary work. That is the paragraph 2 says. And what is the originality? Originality is not defined anywhere, neither in the Berne Convention. Berne Convention definition says the selection and arrangement of expression. So that is the originality. Even the database is prepared, selection and arrangement shows a kind of originality. Then patent is not allowed. If you see the Patent Act, Section 3K says computer program per se is not patentable. But when it creates a kind of technical effect in the device, that is patentable. Then who is the author? Person who writes, whose original expression is written in the computer program is the author. Person who writes. You may be writing a book, writing an article. So you have copyright in that. Then nowadays question comes. Artificial intelligence also started writing. You must have all downloaded ChatGPT and must have given various instruction to write in 200 words, 100 words, or 500 words on a topic. It must have written and given it to you. Okay. Then many people say then these artificial intelligence machines autonomously writing, creating a work where there is originality is there. The question of originality I'll come to later. Then how you are an author. So basically, if you see the definition of author in Copyright Act, entire world, you take US Copyright Act, EU Copyright Act, author is a person. But person is not defined. Who is the person? From where you find the definition of person? You go to the General Clauses Act, where you find the person is a natural person or a legalistic person or a juristic person. Your institute, your engineering college is a legalistic person. Dr. Srikant is a natural person. When Dr. Srikant writes a annual report for your engineering college, that is the copyright protected work. And since he has been on contract basis as an employee of that institution, he is getting a certain amount as a monthly salary, and the work created by Dr. Srikant is a part of his job, then copyright automatically gets transferred to the institution. Because while joining the job, he has already signed the contract that I'll be working and creating all these things. But he won't get any copyright, but he may get a recognition of the author of that report. The right to paternity will be there. I'll come to that moralized right. Then, how about the work created by Dr. Srikant individually without getting any instruction from his engineering college or institute? During his leisure time, at home or weekends in the holidays or any other national holidays, he must be writing a book on a particular subject, or he must be writing an article to get it published on the emerging topic in an international journal or Scopus journal. Then university or institute can't claim copyright on that work created by him. The author and owner becomes only Dr. Srikant, because that is not part of his official job function as a professor there. So this is the difference between contract of service and when you are doing individual work. But civil servants also can do that, but simply they have to inform. There is no need to take permission and all that. Conduct rules allows that. But next question comes: what happens when this very engineering college, instead of engaging its own professor and employee, Dr. Srikanth, engages some other expert from outside industry to write the particular report, a research report? Then it is called commissioning of that particular work. A contract has to be signed between the institute, maybe signed by your director, dean, or registrar, or that authority has been given to Dr. Srikanth himself. What happens? That MOU, the contract signed between that particular firm or an expert, contains transfer of copyright provision. Once that report is created, the entire copyright will be transferred to your institute, because you must be funding 1 lakh or 5 lakhs to that person or institute create that work. You own that work. He must have researched and written, but that is funded by institution. Automatically that work has to be transferred to you, the copyright. Otherwise, what will happen? You simply ignore that transfer of copyright to you. He will publish that as a book and start earning money. That is illegal. But you can't call it illegal, but because inadvertently you forgot to include the transfer of copyright paragraph in your contract. But what happens? The many occasions, despite there is a written contract provision that the person, expert or agency has to transfer the copyright, and they won't own the copyright, but stealthily, illegally, they get it published. This is wrong. If such thing is done, you can send a legal notice, and if they don't withdraw those copies or give any compensation, damages, then you can file a court case and get a civil injunctions to stop the further publishing and distributing and sale of such books in which copyright belongs to your institution or university. This is very, very important. Coming back to artificial intelligence. So when Dr. Srikanth is a person, natural person, and this very engineering college institution is a legal person or a juristic person, what is the status of artificial intelligence, which writes the books or writes the articles, writes the project works? And not only this machine learning or deep learning algorithms, there is a generated neural networks are there. What is the role of this? These are very advanced artificial intelligence algorithm, generated neural networks. You feed, beautiful photographs of Raja Ravi Verma. There may be thousands of photographs of Raja Ravi Verma. Okay, you feed it to that. Let us say Dr. Srikanth feeds this to a particular artificial intelligence machine in its engineering institute, developed by the various AI experts in your university, which has generative neural network. And you ask that machine, create a painting based on today's event. Immediately within a seconds, that machine creates a painting that I may be lecturing copyright law or some other resource person lecturing some other topic, and various others are listening, sitting in a hall, in a university conference hall. Entire style of painting is Raja Ravi Verma. No one can believe that any other person has painted except Raja Ravi Verma. then Raja Ravi Verma is not alive. He will not get copyright. So, can you give the copyright to that machine because it has autonomously created and there is originality in that? But you can't give copyright to machine. No law allows. I'll give you best example of Stephen Thaler. Stephen Thaler is a AI scientist, engineer, expert. He created a machine, artificial intelligence machine, which has all kind of algorithms like machine learning, deep learning, and generative neural networks and all that. He fed a famous 15th century Dutch painter called Rembrandt paintings and asked him to create one more latest painting after feeding 50 popular paintings, portraits of created by Rembrandt, a Dutch painter of 15th century. I remember when Amsterdam Museum, when I went, I enjoyed looking at the various paintings of Rembrandt there in that. And a couple of paintings are there in the Louvre Museum of Paris when I visited. Because an art enthusiast, as an archaeology person, I always show interest in these subjects. And then he claimed copyright ownership for that machine for not himself. He filed an application in US Copyright Office. It was instantly rejected by the examiner, saying that as per the US Copyright Act, author of a painting is a person, means natural person. They doubles a machine, artificial intelligence based one created by Stephen Thaler. Even though it has autonomously created Rembrandt painting, it may be having originality. Copyright cannot be extended to it. Simple. And I take you to the previous case of the US. There was a David Slater, a British wildlife photographer settled in America, went to Indonesian jungles. He put his tripod with a very high valued camera and looking for a spot to cast the various snaps. In the meantime, one macaque monkey came and took a beautiful selfies. And that monkey is been given a name called Naruto. So when he started commercially exploiting the beautiful selfies taken by that Naruto macaque monkey, what happened? PETA came into picture. That people for ethical treatment of animals, they, while protecting the ethics, they simply destroy the human rights also sometimes. For them, the animal rights are important. They said, this guy, David Slater, exploiting the copyright owned by the monkey because as per the copyright law, person who clicks the camera is the author. Their argument is David Slater simply fixed the camera there on the tripod. He didn't collect the camera to take a photo of that macaque monkey. Monkey itself came, took selfie. Not one snap. There are about 50 snaps. They went on kicking. And each and every copy so beautifully came, smiling monkey. You can Google and see that photograph. Then he won't own the copyright. Monkey owns it. Entire money should go to monkey, not to him. He's exploiting. They filed a case in the court of first instance in the US. They lost the case. They went to a court of appeal. They lost the case, and matter ended up in the Supreme Court. And this guy thought, "Arey, what I am earning, entire money is going in the legal litigation. And then let us have a mediation." And he entered into mediation with the PETA and promised them that he will spend 25% of the commercial proceeds for the benefit of animal welfare. Then they withdrew the case after signing the mediation agreement, settlement. So these are the funny things happening. And coming to the originality in the copyright, just like in a patent, you have novelty, inventive step, and commercial application. In copyright, only the test of originality should be there. What is the test of originality? Question came before the UK Privy Council. They said that Sweta bro rights he works hard in writing a book or a poem and all that. Just like a labor, sweating is there, author also sweat comes out. So sweat up, bro. The labor and skill of the author, they said, in various cases. So that common law concept was adopted by Indian courts as well, not only in India, other courts. But when this was going on, recently, a few years back, a beautiful case came up before the US Supreme Court. It is called Fiest Publications versus Ruler Telephones. Here, question came about originality. तेरा भाई क्या हो रहा है इधर? What's happening? So US copyright, issue came before the US Supreme Court. They questioned the originality and copyright involved in creation of Yellow Pages. The Yellow Pages famous book where you find telephone numbers, addresses of service or any other products and businesses, organizations. So the challenge was there is no originality in this book because anyone creating similar thing is not infringement of copyright of Yellow Pages. Court said yes, because there is no originality in that database. Even the TRIPS agreement and the Article 10.2 of the TRIPS agreement, Article 2 of the Berne agreement, including the WIPO copyright treaty, says the selection and arrangement, as they said. Selection arrangement means there is a originality, simply not picking the telephone numbers and addresses and arranging. There should be a minimum degree of creativity. That's what your Supreme Court said. You can't apply the common law concept of, there is a sweat up, bro, there is a labor, there is a skill and judgment in keeping that. No, there is no creativity in that. Creating such a list of addresses. US Copyright, as per the US Copyright Act, the US Supreme Court rejected copyright protection, lack of originality to Yellow Pages. They said there is a need for minimum degree of creativity. Then another major case, similar case came before the Canadian Supreme Court. So what Canadian Supreme Court said, there's a famous case called CCH Canada Limited versus Law Society of Upper Canada. In this case, Canadian Supreme Court said the concept of labor, sweat of bros, skill, judgment is a lower test for deciding the originality. The minimum degree of creativity is also won't help. There should be a modicum of creativity, they said. They said a stronger kind of originality system they introduced. But that was not accepted by the Supreme Court of India in Eastern Book Depot versus DB Modak case. What is this case? There are Supreme Court judgments. If you go to Supreme Court website, anyone can download Supreme Court judgment. It may be from 50 pages to 500 pages of, I remember Ram Janmabhoomi decision was 1057 pages because I had to do some analysis, official purposes. And what happened here? The Eastern Book Depot have a database called SEC Online. Those who subscribe that get a copy edited judgment. These 1057 pages of Ram Janmabhoomi Ayodhya judgment will be edited into 50 pages, only relevant paragraph where ratio is there, argument is there, submissions are there, interpretation is there of law, and also evidence that they call out in a systematic manner and arrange. And after arrangement is there, they give an executive summary and also conclusion by these people, creator of this, and also wherever necessary, they give a kind of explanation and comments. This is the beauty of copyrighted judgment. It helps the lawyers, instead of reading 2,000 page judgment, readily they got all information available to them, a kind of summary. That is the beauty of this thing. What Eastern Book Depot said, we can only make these kind of things because we have copyright in the Supreme Court judgments. DB Modak or any other competitor in the market are not allowed to make such a database and prepare such copyrighted judgments or summaries and sell in the market to other lawyers or can attract our clients. So it is ridiculous. That's what Supreme Court said. Supreme Court said, because it is ridiculous argument. Why? Who wrote this judgment? Supreme Court judges write this judgment. They have copyright in that. It's a collective work. There, when two or more authors are there, it is called, there's a collaboration, sometimes they write separate judgments, means they have copyright individually. Finally, sometimes they write combined judgment, is a collaborate, two or more authors writing. But still they won't get copyright, even judges, because they are employed by the Supreme Court. They are drawing a salary, monthly salary. So entire copyright go to the Supreme Court. So as per the copyright law, all the institutions have 60 years exclusive copyright. Then Supreme Court has that copyright. And they have put it in the public domain. Go man, anyone can download and use it. They are relinquishing their copyright. They are not asking anyone to take permission and pay royalties, take a license. Then how Eastern Book Depot get copyright on that? If we are downloading and preparing a summary, anyone in the world, any Tom, Dick and Harry company can do the similar thing. But where is the originality in the SEC online summary or a copyright judgment? The kind of expression, okay? The kind of expression written by the authors of SEC online summary or copyright edited judgment in that executive summary or explanation or comments or conclusions, and the way they culled out the important lines and the way selection and arrangement has been there is a minimum degree of creativity. Similar to the fierce publication and rural telephone, Supreme Court of America concept, they adopted, rejecting the earlier common law concept of labor skill judgment of the British, and also rejecting the modicum of creativity, higher originality concept introduced by Canadian Supreme Court in CCH Canada Limited versus the Law Society of Upper Canada. So beautiful. It is extended to any database now. And the question of database comes. And WIPO wanted to introduce post-developments of this rural telephone and CCH Canada cases, while WIPO internet treaties were being negotiated. What happened? They wanted, non-original sui generis treaty for protection of databases. But copyright comes with the originality. What is this non-original protection? They say that even though database created, even though there is no originality, but such creation involves billions of dollars or millions of euros. When an entrepreneur is investing such huge sum, that need to be protected. And the competitor in the market copies it and makes money. So since copyright protects only originality, there should be a standalone sui generis treaty. So India and other countries said, don't spoil copyright law. Bichara, copyright is protected only by remove that originality also. No, because anyone puts money, you can't get law. You can't buy law. That is the concept. Rule of law is there. You have money, you are creating something, you get copyright, we don't agree. If there is no originality, there is a secrecy in that document, that database, and there is a concept of undisclosed information. in Article 39 of the TRIPS. That's what 39.3 of the TRIPS called protection of undisclosed information. That's what we common term is called trade secret. And in India, trade secret, there is no law, but we protect it through Section 27 of the Contract Act Non-Disclosure Agreement. And another concept here is idea and expression dichotomy. Only ideas are protected. Expression is not protected in the copyright. You get an idea. If you have to express it, if you don't express, and there's no copyright. That is very, very important. Then, before I conclude, I want to tell you the most important thing, the exceptions and limitations. People talk about fair use, fair use, fair use, but there is no concept of fair use. Fair use concept is there introduced in Section 102 of the US Copyright Act. India is a sovereign country. We have our own Copyright Act 1957, which was amended in 6 times. The last time in 2012, for which a draft have been created by me as a civil servant working in the Copyright Office, heading the Copyright Office at the time in 2012. Then, what is the concept of limitation and exceptions of copyright provided in our law? That is called fair dealing, not fair use. What is this concept of fair dealing? We borrowed it from the English Copyright Act. It's a common law concept. What is fair dealing is not defined. Fair dealing means a list of exceptions, like exception for education, teaching in the classroom, and preparing notes, course packages for students, and for research purposes. Research must be the non-commercial research. And then for any cultural program, you use any music, song, or film for the non-paying audience is there. And creating a kind of anthology for education purposes. And also creating digitized versions of the books available in the repository of the library for the only internal use only. And also there is a criticism of a review of a book or any other work. Means it includes parody and creating a meme also. And for the legal purposes, advocates, while filing the affidavit, they cut and paste various information. Sometimes they give citation or don't give citation. Giving citation is ethical and moral, but it's not taking such information without permission and license using in the legal document is not infringement. Exception has been given. Similarly, judges writing the judgments. Okay. And they also use many quotations, quote unquote. Sometimes they do give citation and don't give. That becomes a big controversy sometimes. Some judges who has a right head on their right also, they apologize and try to rewrite that judgment, come out with a new version and all that. But not taking a permission and license, such exception is given that purposes. Even for the legislative purposes, whether it is the parliament or state legislature or someplace, whether it's Lok Sabha or Rajya Sabha, when photocopies of any chapter or a book which became controversial. I remember when I was a student, the satanic verses of Salman Rushdie became very controversial. And at the time, the so-called secular government banned that book. And there was a controversy in the parliament, and the copies, the chapter were photocopies and placed on the both houses, tables of both houses of parliament. They must have made 1,000 to 2,000 copies. So right to reproduction is with the author or right owner. Exception has been given such purposes. And another important area is an amateur artist singing, expressing. He need not take permission because he is not doing for the commercial purposes. And recently, the controversy about the use of songs in official purposes and also for the marriage ceremonies. A written article and use of copyrighted works for these purposes. Copyright Act section 52, which gives limitation and exception, follows the fair dealing model, which gives list out the activities where exception is provided. Clearly mentions section 52, paragraph 1, ZA, that use of works for the marriage ceremony. Marriage ceremony includes any rasam you are using, because you are not commercializing your daughter's marriage or son's marriage, but it is a religious ceremony. Exceptions are given. And also government ceremony. When the songs are used for the Republic Day or any your college function, inauguration or government launching of any scheme of program, that is not for the commercial purposes, exceptions are given. And apart from marriage and official government, religious ceremony, sometimes, especially you see the temples, or sometimes in Jagrata, various songs are sung, which are copyright protected. So there is no need to take license and pay royalty for these things. But once I remember, IIT Mumbai approached me to give an advice that they are using music which is sung by because many Bollywood music composers staying in Mumbai and singers volunteer to participate in IIT Mumbai annual function. So it's good. They're volunteering, with charging any money and giving performance for students, the professors and the families. It's well and good. But what the mistake, and they need not take any license and pay any royalty for this. That is clear. But what the organizers did, knowingly and unknowingly, they said any public can come. If a bona fide professor, bona fide student, or a researcher coming to attend this along with the families, showing their identity card, okay, they are allowed. But any nearby Mumbai community, neighborhood community want to come, they come, but they have to take 500 rupees pass or 50 rupees pass, whatever minimum. Then immediately IPRS, the Copyright Society, which manages the rights of these songwriters, music companies, music composers, and including the music company society called PPL, sent a notice to them, Bhaiya, take license, and then only allowed to function this program. Otherwise, we'll already sent a copy of this notice to police. They will come and raid and close your program. They rushed to me. Then I read them out the copyright provision. Why the exception is given to you for only non-paying audience. The moment paying audience comes, the exception is gone. So the tickets you have printed and allow the general public also freely. Or if you don't want to allow, don't allow. But the moment you charge 50 rupees or 500 rupees, you will have to pay royalty to the owners of the music. And that is the beauty of the copyright law. Then what is the difference between fair dealing and fair use? The fair use in the American concept is that it is open-ended. There is a Supreme Court case which explains the fair use called Folsom versus Marsh, Supreme Court of United States of America. It says fair use is a concept which is an open-ended concept. If any work you use for the transformative use, for education purposes, research and all that, that has to be put to 4-factor test. What is the nature of use? What is the purpose of use? What is the amount of work used for this purpose and nature? And finally, what is the impact, economic impact of this on the original author or original right owner. Then, based on this concept, since it is open-ended, need not list out the exceptions. Even AI came, 3D printing came, the new technology coming up, this can be applied. Okay, but fair dealing, unlike the open-ended, the fair use, it is a restrictive to the list of exceptions provided in the fair dealing. So if a new technology comes, text data mining comes. You use text mining for your research purposes. From various articles, it text mines and gives you data. And the journal you subscribe by your library, monthly subscription, disallows such text mining. It says you have to take a separate license. But you say that, yeah, why should I pay? I have a research exception, education exception provided in my Copyright Act. So this is a tussle. There's a contractual override that need to be removed when the new technologies comes. For that reason, Copyright Act to be amended. And another question comes, the infringement and plagiarism, which most of the academic community. Infringement of copyright. Take again Dr. Srikanth. I'm liberally using Dr. Srikanth here. Dr. Srikanth has written a book, and he is earning good sum of royalties, and it's become very popular, and it has become a book prescribed in that subject by various universities. But unfortunately, the copies are not available in various states. Some unscrupulous persons start printing that book, passing on as if the right owner, their publisher and author is printing, started selling it. It's a pirated book, everyone knows. The publisher knows that I have not printed, supplied to that area, even author, Dr. Srikanth knows. So it is a construct of law. The law clearly says, section 52, what is infringement? Without the permission of author or a right owner, printing, any exploiting any economic right. What are the economic right copyright gives? Right to publish, right to reproduce, right to distribute, right to communication to the public, right to translate, right to performance, right to transfer the rights. These are the bundle of economic right author gets. That Dr. Srikanth got that book, which is being exploited illegally. Even the buyer of the book knows it's a pirated version, and the author knows, everyone knows it's a legal. It is explained in section 52, and there are civil remedies. The moment it is being done, Dr. Srikanth and his publisher go to that particular state and file a case seeking injunction, stopping that publication and reproduction and selling that book, and also ask the police and go and seize that printing machine and left out books, ask for either damages or accounts of profit. Or sometimes they may take John Doe orders that unknown people who are all do indulge in illegal printing should be stopped. Okay, but what is plagiarism? In infringement, piracy, everyone knows that is a pirated version. Plagiarism is most dangerous. There may be a single source plagiarism. One book is there somewhere, and person will copy entire book and try to pass it on that as if he has written that book. That is plagiarism. Maybe writing a project work, writing an article, anything. It is called single source plagiarism. Then comes some intelligent people, why I may get caught if I do the single source plagiarism. Is an intelligent guy does he will read 20 books or 1,500 books, does copy paste and does the selection and arrangement as if it is original without citation, and come on, it's the original work, he will make money. And third version is ghost writing. That person can't do. no time, but he has a lot of money. He will ask someone, he will fund someone, get that book written legally with all citation, paragraphing, referencing, beautifully chapterized everything. And he will pay lakh or 2 lakh rupees, submit it as a project work. That is called ghost writing. It is also a kind of plagiarism. The most intelligent guy, how he does plagiarism? He does paraphrasing. His English is good. He will paraphrase and pass it on his own. But the main idea, the expression is still there. It is smiling from his paraphrase paragraph. Even though he has done paragraph, he has to give citation, which he is not giving. That is illegal. That is plagiarism. And nowadays, technology has given rise to more plagiarism. What is ChatGPT is doing? It writes a paragraph, it writes an article, it writes a paper. Does it give any citation? No. It simply picks up, does the text mining, data mining, does the paragraphing, submits it to you. And no citation referencing is there. It is plagiarism, literally plagiarism. High-tech plagiarism is being done by artificial intelligent machines. This is the danger posed by these machines, disruptive machines to authors and writers. With this, I stop here. If you have any questions, you can ask.
Thank you, sir.
Yeah.
Any questions from participant?
Hi, can I ask one question? Can I share my viewpoint on some aspects, please?
Sir, I wanted to ask a question from Raghavender, sir. Sir, I'm an author and I'm writing an article and I'm using some image of which is already available at some website. And what I'm doing that after putting that image at the bottom, I'm mentioning the source.
Okay.
So am I copyright issue is there? Is it any copyright issue?
One thing, my friend, I think you were Manish asking this question.
Yes, sir.
Yeah. Look, my friend, whatever available, whatever content available in the internet, it is not in copyright free. What people think, it's a misnomer to call it a public domain work. What exactly a public domain work? When copyright, duration of copyright in India is life of the author plus 60 years. A concept called post-mortem auctoris. It means post-mortem is after the death of the author, 60 years the length of copyright is given. Why this concept came when the law was introduced, copyright law in the Britain. Slowly from 14 years it started extending to life of the author plus 25 years. Why this concept was introduced in 1832 in the British legislation? Because they thought sometimes author passed away without seeing his work becoming famous. Most sold, most famous painting or most popular book, and his entire family is still in poverty. So after that, it became famous, most sold book, popular book. Then other people are exploiting and family is still in poverty. To extend that economic benefit, they introduced 25. But entire legislation, British legislation supported it. Only person opposed was the Lord Macaulay. The person introduced English education in India. He said, you are killing the innovation and expanding the copyright. Know that the public interest is defeated, but still the majority went ahead and introduced this. So a work enters public domain after completion of 60 years after death in India. When this 60 years starts, let us say today some author has expired, unfortunately. Today is 4th March, and the counting does not start 60-year counting from today or tomorrow. It starts from next calendar year, that is 1st January 2024, 60 years counting start. So do you think that the work which you have taken, the photograph, the life of photograph be increased from 25 years, 60 years to life of 60 years in 2012 amendment, because the digital networks are increase the life of the copyright. So the photograph owner must have died. The person who was taken, author of that photo must have died, but relatives must be alive. Or it must be owned by some company. So you have addressed 50% problem. You've done a great thing giving the source and given a citation, but you have not got a permission. Let us say that is freely available, means it is the work become orphan. It is an orphan work, but copyright exists in that. There is a provision we introduced in the Copyright Act. While using the orphan work and creating and make copies, you don't find the author or a publisher. You have to give a public notice, advertisement in the local newspaper, one English and other regional language, perhaps that may belong to that area. After 1 month, no one comes, you have to approach. Earlier, it was Copyright Board. After Copyright Board was closed, in the first phase of tribunal reforms, IPAB came. And second phase of tribunal reforms, IPAB has gone, and the respective jurisdiction of High Court comes. If you are from Madras, if you are from Maharashtra, Mumbai High Court commercial bench has that right, where you will file an application seeking to using this for the commercial purposes, seeking orphan work license. That minimum price will be fixed by the court, and that you will pay. So all this to avoid the further, and I'm not complicating the issue, but explaining what is the law at this position. Okay, you're done that. Very good thing, giving the citation of the person to whom the right belongs, copyright. But if he emerges, then you will have to pay. If he freely allows, it's okay. If you are using for the non-commercial purpose, non-commercial research purpose, it's okay. But
yes,
you are
sir,
exploiting
I just posted it on LinkedIn, sir. It was just an article for road safety week was going on.
Then it's a non-commercial. You need not worry.
Yes,
you have done a great thing by giving citation. But if you are using for commercial purpose, then you will have to use this orphan work licensing method, which I have explained.
Got it, sir. Thank you for your insight, sir.
Can I ask a question? It was indeed a great illuminating talk. Is there any provision under copyright for compulsory licensing? If at all, an existing enforceable copyright is a barrier to someone's own creation, wherein he has to use this work. Is there any provision for compulsory licensing instead of taking a license from the copyright owner?
Yeah. Compulsory license provision, which India got this opportunity to introduce compulsory license because it is India which fought in the various Benn Convention revision meetings. Right in 1967, India fought there, got a Benn protocol created, the publishing of works, because at the time 60s, all books were published by multinational publisher from West, the content givers, so-called. India was, even though now it is a leading third highest English publisher and the fifth largest overall publisher in the world. And we wanted compulsory license because various languages, these books are not available for studies. And also not only for the reproduction, but also for the translation India wanted, which they denied, even though Berne protocol for this licensing was finalized. Finally, a watered down version was finalized as Berne Appendix in the Paris revision of Berne Convention in 1971, which India introduced these compulsory license phenomenon in 84 Amendment to Copyright Act. If you see that section 31 of the Copyright Act, it provides a compulsory license for the broadcasting. If a license is denied, for example, you go and seek the voluntary license for your business. That guy is not giving to you. हम नहीं देंगे. नहीं तो he will fix the royalty. बोलते भाई 1 लाख का होगा. अरे भाई मैं 10-15 हजार से ज्यादा नहीं दे पाऊंगा. आप you are trying to kill my business. My economies of scales won't allow me to pay 1 lakh per month. 1 lakh per work. I need 20 works. मैं 20 लाख दे दूंगा. मेरा सारे profits तुम्हें license भी देने पाऊंगा तो मैं रोटी क्या खाऊंगा. Then you rush for the compulsory license. If a voluntary license is denied. And that is there for broadcasting purposes, there 31D for radio and television broadcasting. And their cover versions after 5 years of original music comes out. If you are a singer, you can sing your own version can come out. That is a statutory license is fixed for the purpose. There's a concept of statutory license and compulsory license. Both versions have been introduced in the Indian Copyright Act. Thank you.
I would like to rather mention one thing. If at all Dr. Shrikant does some research, instead of getting it protected through a patent, he does a publication which is standard practice among scientists and technologists.
That is the sad thing happening in India. Why, despite India having third largest scientific engineering community, why are not the third largest, at least if not the first, not third largest patent filing country? Why China has become first, and then US, EU, and Japan and other? Because we are foolishly, because we want to see our baby in the print. We don't want to protect it.
Exactly.
That's why this concept came. Publish and perish. The moment you publish,
my point is,
patent give economic. So file a patent and then publish.
I think there is a provision, even if you publish first, same author of the publish has a provision to get a patent within 12 months after the date of the publication. Same author. No, but other author cannot do it because of prior art. That prior art is not rather a prior art for the same author for patent. That provision is there in that.
I know that because I don't want to venture into patent council because this is not a patent law class or a talk. But I'm a conventional IP person. Don't take the risk of that provision of publish and file patent and then go publish.
Because copyright does not provide you protection against the technology.
No. Copyright is for expression, not for the technology. Not for the technology. Only patent can protect the technology. Where the product or a process.
We must be rather aware of this aspect.
Copyright सिर्फ आपका article ही protect रहेगा. Device somebody will make and start selling it.
Not technology in that article.
What I'm saying, sir, if you publish first, go for the patent. That period, and the intelligent guy, because even though you will file the patent, I'm telling you the problem there. You publish it. You say that provision has 12-month window. मैं 6 महीने में फाइल कर दिया और immediately फाइल कर दिया after printing it. So what I do, I'm an expert. I will do better work than yours.
That's true.
Based on that knowledge, I will pass the test of novelty, inventive step, commercial application.
I agree with you.
I will file first, and your technology is gone in the dust.
Yeah. I agree with you.
That happens. Yeah.
Yeah.
Please. Shall we close it, Dr. Srikanth?
Thank you, sir.
Thank you, sir.
Thank you.
Good
And Jai
afternoon.
Hind, wish you all the best. And thanks, Dr. Srikanth, and also Dr. Vikas sir, for giving me this opportunity. Thank you. All the best.
Thank you,
Good
sir.
afternoon
Thank you.
to one and all. I deem to great honor and privilege to propose the vote of thanks on the sixth session of FDP. First and foremost, I thank our today's eminent speaker. I was really delightful to hear such a detailed and informative session. Thank you very much, Dr. G.R. Raghavender, sir, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. We are really obliged to hear you. Sir, you explain many things about copyright, insight, and related strategic issue. In your session, the things are really difficult, but you make us understand it is very simple in simple manner. First and foremost, I thank our today's first session eminent speaker, Dr. Raghavender G.R. sir, who despite from his busy schedule has found time to grace this occasion for giving us valuable information on topic. Copyright example like music, literature, computer science programming, and also detail important of intellectual property, industrial right, and their related judicial dispute and judgment worldwide. On behalf of SPEC, Mumbai, SHGB, COIT, Bhusawal, Dr. Dinesh Patil would like to convey my sincere thanks and appreciation to you for imparting us your excellent knowledge and for providing technical skill to our participants through faculty development. Thank you once again for being with us. We are grateful to you for your true help. The session was termed a grand success due to your earnest involvement, and we are all inspired by your great expertise knowledge. I hope you will contribute in the same manner in the day to come for such activity, and thank you once again for inspiring your precious time. A heartfelt gratitude to our prestigious speaker and great aspirations to our beloved participant for being a positively throughout session. Thank you, sir. Dear participant, I would like to inform you that today's first session is over. Now, dear participant, second session will start immediately. Google Meet link for the session will remain same.